Welcome back to the Crime and Law Network. I'm Kenya Johnson. You just heard a recap of the Kentucky case of the Marine murder. Such a tragic case involving someone who had pledged to serve our country, and his life was ended in such a tragic way. We're joined here in the studio by trial attorney Brad Micklin. Thank you so much for joining us again.
Thanks for having me today.
Now, there's lots of discussion about guns and forensics. Can you tell us the importance that the ballistics play in this case and how the connection was made?
Sure. Well, there's a lot of issues in this case about the forensics with the guns and who had the gun, how did it actually come into possession of the police. So I think this case is going to be using a lot of forensics to tie it all together, because we had first the gun was in the possession of the two victims in the hotel 6 days earlier. Then there was the robbery, and then it went into the possession of the two defendants that we have here. And then it was eventually, after a crime spree, turned into a third person who turned it to an undercover agent. So I think they really need to try to tie those three pieces together in order to make the forensic make sense to the jury.
So I noticed that the defense attorneys are looking to exploit the break in a chain of custody. Of course, they're going to argue that somehow, some way in that chain of custody that there was the gun had been switched out, or trying to poke holes in the reliability that this is the very same gun that was taken in the motel robbery. And so tell us, how important is it for the state to make that connection, and how much can the jury rely upon the chain of custody in this case?
Well, that's going to be a challenge, I think, on both sides of the case, because forensic evidence is always important. Scientific testimony is, on the one hand, very helpful, but also, on the other hand, can be very challenging for the jury to understand. And because it's never an exact science when you have an issue like this, it's going to be hard for the jury to process the markings, for instance, on the casings to the testimony. And I think the defense counsel did a really good job of trying to show there's some inconsistencies in this scientific analysis.
And you're right. Scientific evidence, ballistics, can be very technical, and so it is important for the state to break it down into small pieces. And then, as you noticed, as he did the comparison of the lands and grooves in the striations of the bullets, you could see the connection. And so when the jury is able to eyeball and see the connection and find out how important forensics are, how the grooves get on the shell casings, that is very moving for the jury. And so I do believe that the state is doing a good job in making that connection, and it'll be ultimately up to the jury and how they process that. And so tell me this, what has been the most emotional part of this trial that you can recall thus far? What do you think the jury is dealing with at this time?
I think the most emotional part of this trial has been the wife's testimony. You know, she was not only a victim personally by being shot, but she lost her husband who died in front of her. And during her examination, they played a 911 call that she made to get help. And when you listen to the tape, it's quite amazing that she is calm through most of it, and then she just becomes so emotional she can't manage it.
Absolutely. She saw her husband die right in front of her.
Right. It was very challenging for the jury, I think, to hear that kind of testimony and to try to separate the emotion from what's actually happening in the courtroom.
Absolutely. Well, thank you for that. We're going to go into the Gebhardt trial. This is the trial in Georgia. It's a 34-year-old cold case involving what is alleged to be a hate crime. And so let's look at that recap. We'll go into the courtroom now. Welcome back. We just heard testimony in the State versus Gebhardt trial. This is the hate crime murder that occurred in rural Georgia back in 1983. We're joined in studio with Brad Micklin. Brad, I was just reading that it was in 2009 that the Hate Crimes Prevention Act, a federal law, was signed into law by President Obama, and that expanded the 1969 hate crimes law. And it included such things as gender, sexual orientation, gender identity, and disability as well. So that was something good for our country and protects a lot more people. Tell me this. This happened in 1983. What are some of the differences in prosecuting and defending this case if it were to happen, say, this year?
Well, I think there's a lot of problems that come up in a case like this. I mean, as you know, every defendant has the right to a speedy trial, and yet this is a case that's been open in some way or another for over 30 years. So the prosecution's had, you know, all the time in the world to put all their evidence together, whereas the defendants are only now put on trial, and we're not even sure when the investigation resurfaced. But I think these issues about the time is going to really affect how the case progresses.
Now, for those that question, this occurred in 1983, and they're thinking, you know, could there have been hate crimes as recent as that? That's modern history. Well, did some looking back, and Georgia is the home of over 4,000 lynchings, and actually they were, and we call this a lynching, but it's actually called lynching by dragging. This is not new. And as recent as 1998, James Byrd in Jasper, Texas, was drugged in this very same fashion. So dragging someone in a car for 3 miles or so on a rural road is something that has been seen as a hate crime for quite some time. What do you think about this type of activity happening? This isn't the 60s, this isn't the 50s or the 30s, but in 2009, this is still happening. What are your thoughts?
I don't think anybody would ever deny that this is a heinous, savage crime, whether it happened in 1983, 2003, or yesterday. You can't get around whether it's racially motivated or not. It's going to be a serious, serious act, and anybody who's punished under these kind of either the hate crimes or tried for murder for something so savage is going to be very significant to them.
Do you think the jury makeup, if this case had gone to trial in the 60s and the jury makeup of 2018, do you think that that is more goes toward the prosecution being successful or the defense being successful, and why?
Well, it's hard to say at a stage like this. So when you have a case that has this many issues regarding racial tensions, witness issues, forensic problems, don't forget the whole case is coming down to reasonable doubt. And you only need to have one person that has beyond a reasonable doubt question about any one of these issues. So whether it's one of the jurors that is emotionally tied to a racial incident, or one that even identifies with the defendant, which is quite possible, whichever side a juror falls on could influence his or her decisions.
Well, you have to remember that the jury is going to be picked from this community, and so whatever the community values are, be it older values or more modern progressive values, they will bring those thoughts and experiences and beliefs to the jury room as they deliberate. So now we'll go next up to hear the testimony of Patrick Douglas. Now, Patrick Douglas is going to tell us that the defendant, Mr. Coggins, that Gebhardt actually confessed to him that he killed the victim, Tim Coggins. And so we'll hear about that, and we'll talk about it on the other side. Welcome back to the Law&Crime Network. I'm Kenya Johnson, and we're joined in the studio with Brad Micklin, a trial attorney. So, Brad, we just heard testimony from Patrick Douglas, otherwise known as Trouble. And Trouble tells us that the defendant, Gebhardt, actually bragged about killing the victim. Can you tell me, why do you think throughout the years, and from the very beginning of the trial, we've heard testimony that he sort of bragged about this incident or just gave little hints that he was involved with it? Why do you think he was so vocal about his participation in this murder?
Well, it's hard to say. You know, the biggest trouble that a juror will have, and I always have commenting about murder trials, is trying to attribute rational thought to some kind of irrational act. And don't forget that there are a lot of issues about the statements that are being made. One of the witnesses is alleged to have some incentive because he's incarcerated. There might be favorable sentencing that he's receiving. And some of the other witnesses have commented that the statements may not have actually identified him as killing the victim. He used a racial slur, so I'm not sure if it's even being tied properly to the victim in this case.
Well, have heard some testimony about where he has actually specifically said that he was that he rescued. In this clip, we heard he rescued Debbie. He felt some sort of responsibility for this woman. So we have the motive there. I think that they are establishing that motive. But tell me why you think that I wonder if he really thought that this day would ever come, that he could, that he was amongst friends in this community, that he thought that people wouldn't put these little comments together. And that's what this trial is all about, putting all the comments together, all the evidence together to eventually link it to him. I noticed as they go over the testimony with Patrick Douglas, they mentioned that his nickname is Trouble and that he has some tattoos and that he's had some past convictions. Why is that important for the jury to hear about his past criminal history?
Well, it may and may not be important for the jury to hear, and in a lot of cases, often people feel that it's improper for a jury to hear about prior bad acts. So fortunately, we have a lot of rules and standards about what can and can't be admitted so that in one case, if it's being used to suggest that a person would have acted consistent with a prior bad act, we may not use it. But if it's being used for motive or bias, then maybe it's appropriate. So it really depends on the circumstance and why it's being offered.
And it's definitely going to take a skillful defense attorney like you to make the difference and still get in that information to let the jury know that the defendant does have some sort of history. I will tell you this, as a prosecutor, we take our victims as we get them, and we take our witnesses. And even every witness to a crime does not have a stellar history. And even though they may have some past convictions, that doesn't take away the fact that they may be a witness to a crime. And so we just have to balance that with what they can offer the case versus with the way that they've lived their life and try to make that difference. What are you saying out of this witness here with Patrick?
Well, it's hard to say. Again, you know, this case is sort of in its early stages, and as we're getting more identification issues and more evidence issues about the knife that's been found, and then you converse it to all the missing evidence and the DNA questions, it's hard to see where it's all going to be tied together. I think it's going to be a very confusing puzzle for the jury. Absolutely.
Definitely more to come. Next, we're going to listen to the top 10 stories around the country. Definitely some things that'll make you go, Stay tuned. We'll be back with more. Welcome back to the Law&Crime Network, where we are covering the State versus Gebhardt trial, the the Georgia hate crime trial involving Timothy Coggins, who was stabbed and dragged in the back of a vehicle. This case is over 30 years old. It's a cold case, and we are hearing testimony from that era, 1983. In studio, I have Brad Micklin with me. I apologize, Brad. Micklin. Brad Micklin, a trial attorney. So, Brad, we just heard from William Sanders, and Sanders tells us that he was friends with the defendant and that the defendant said that the body you found we put him there. First of all, I commend Sanders for even telling this. He says that they're still friends. They were friends throughout this, but he never had any follow-up questions. He just received the information, and then they just went on about their lives. What do you take of this, a friend and the information that he had?
Well, it's pretty incredible testimony. I didn't realize that it was going to be so damaging. You know, when you listen to the opening statements, both the prosecutor and the defendants, they didn't suggest that there was going to be such a direct tie in this witness to the victim. So it's pretty shocking that he's sitting on the stand saying that he said he did it. So I'm really interested to see what the defense cross-examination is going to be.
What comes to my attention is, how is it that investigators missed speaking with him? Now, this is the witness that found the body, and they didn't follow up with him afterwards. So what we're hearing is that a couple of days later, the defendant admitted to his friend, Sanders, that he put the body there. So there was no follow-up, perhaps a week or 2 weeks later, with this particular witness. And so the witness tells us that he knew someone, a narcotics agent. 3 days later, after this confession, he told this narcotics agent, and nothing was ever done. What does that speak to you about the culture in this town and how they handled and felt about this crime?
Well, we're not sure that nothing was done. You know, there's been allegations of a cover-up both in 1983 and even in the current investigation. So it's shocking that they would have this kind of testimony and not cover it up, regardless of the racial climate, both then or now. So it's going to be interesting to, like I said, I want to see what the defense has to say about this witness.
How do you think the jury is going to weigh his testimony? This is a lifelong friend. They are still friends. Do you think that they will find that believable, or will they look at him in a weird way because he now is telling on his friend and maybe he has some other motives?
Well, it's certainly strange that he's sitting there saying, I still am friends with this man. If a friend of mine tells me that he killed somebody, it'd be pretty much the end of my friendship with him.
And you'd have a few questions, wouldn't you?
But it makes his testimony credible. You know, there's very little reason for the jury to suspect that he has any motive or incentive to be there. He's testifying against a friend of his.
Absolutely. And so this just, to me, shows how this community felt about this crime. I would like to think that something was done, but here it is, some 34 years later, and we're just now hearing about this. He says, the witness says that he just spoke with law enforcement 8 months ago about this case. And I'm sure once they got that testimony, they were all steam ahead on bringing this cold case to actual fruition in a trial.
Yeah, I think there's actually some talk that there's other parties that are going to be charged with obstruction issues and charges too that I don't think they've done yet, because I don't think they want to cloud the media or their coverage of this case.
Absolutely. So next up, we're going to go to the courtroom and listen to the testimony, more testimony as of William Sanders as he's crossed by the defense attorneys. Let's go to the courtroom now. Welcome back to the Law&Crime Network. You are watching testimony in the Georgia hate case. It's a cold case from 34 years ago where Timothy Coggins was drugged and stabbed, and this case has gone dormant for years. We've just heard testimony. We're joined by Brad Micklin. Brad, that was a bomb that just went off in the courtroom. And I view this testimony as some of the most important testimony we've heard thus far. We've got the good friend of the defendant who tells us that the defendant told him that he participated in the crime, gave details, chains, he was stabbed, identified the location, gave all this information. He's just now spoken to law enforcement officially as part of this investigation about 8 months ago. What does it matter that it was over a drug deal or over a courtship or a connection? What do you think that Sanders has been living with all these years?
Again, it's hard to say what goes in the minds of the people that are involved in these kinds of either heinous acts or even the cover-up from it. You know, you said yourself, he testified that he's still friends with Gebhardt, or at least, I guess, as of 8 months ago he was.
They're probably not friends anymore.
No,
what do
I
you
would
think?
hope not. But it was really surprising how limited the cross-examination was. You know, the defense attorney's job in cross-examination is to create reasonable doubt. And here you have something that may almost seal his fate. And we had very little talk about what was relevant. You know, talk about the reason for it. It doesn't matter why he killed him. I mean, maybe it will negate from, you know, malice to involuntary, but murder is going to be murder. So to put such a small cross-examination is shocking. I'm just assuming that the defense counsel is really going to play into the larger issues later, like the missing evidence and the DNA problems, and that he didn't want to make too much of a spectacle out of this witness.
But Brad, you've made a great point, because this is the chance for the defense attorney to rip this witness apart as much as they can. I mean, bring up everything from, you know, a bounce check to, you know, whether his eyesight is good or not. I mean, they could have gone after him in so many ways to attempt to color his testimony, but they did not. So we'll see how the jury takes a look at that and how they view that. Looking at also in his testimony, he talks about this drug deal. So do you think that the drug deal that he would have been more apt to reveal this had he felt that it wasn't? I mean, do you think that the drug deal and the courtship just has any relation to his actions and how he viewed this crime?
Well, I can't be certain. It's possible because, again, the defense counsel's job is to create reasonable doubt. And any defense counsel is going to be as noticeable as they can. I always say cross-examination is more about the lawyer than it is about the witness. So we don't really know what he's going to do with it, probably until we get either other witnesses or a closing argument from him. So I can't really be sure if he's trying to either hurt the credibility by suggesting the witness may be involved in drugs, or if he was just trying to make some kind of question just to raise a reasonable doubt on any grounds.
Cross-examination is more about the lawyer than the witness. I like that you said that, and that was certainly a favorite part of a trial that attorneys look forward to, because that's their chance to just get out everything. And even though it's a cross-examination, you can ask leading questions, and you can sort of plant things in the eyes of the jury. The witness can say yes or no, but it gives you an opportunity to control the narrative as the defense attorney or whomever's on cross, the prosecution or the defense attorney. And so lots to get from this witness, and this is certainly an interesting and very emotional trial, and it's just as interesting as if it had been tried contemporaneously in 1983 when it first happened. Very engaging. And so we're going to go to break for just a little bit, and we'll be back with more coverage of the State versus Gebhardt. There's more to come on the Law&Crime Network. Welcome back. You just saw a clip of the Marine murder trial out of Kentucky. Closing arguments are scheduled to begin on Monday. So after several days of testimony and lots of forensic, heavy ballistics type of evidence, we're finally going to, the jury will finally get a chance to make their decision. Joined in studio by Brad Micklin, trial attorney. Brad, this case has gone on for a while. It lies very heavily on the investigation and matching up a lot of the a lot of the facts and circumstances and evidence. Tell me, this case is a death penalty case. These two defendants are on trial for their lives. What do you think is the reason why this is a death penalty case versus a run-of-the-mill murder case, if you will?
Well, it's hard to comment as to why they sought the death penalty. First, I don't really know what the jurisdiction says. As you know, many states will have different reasons for charging and for sentencing. But I think the aggravating factors that may have led them to choose to go for the death penalty are all the crimes that surrounded the incident. There was the hotel robbery, then there was this shooting, Megan Price was injured also, and then we had the crime spree that followed. So I think in order to sort of dissuade this type of conduct, I think they try to aggravate the charge and therefore aggravate the sentencing.
And it also matters who was killed as well. Sometimes the death penalty in very egregious cases involving children or the elderly. And in this case, we have a Marine, someone who was sworn to protect our country, who's dedicated his life to protecting us, and for him to fall down for such a senseless act of robbery at the brutal hands of two armed robbers, that certainly is shocking to the senses and worthy of additional scrutiny as it relates to the prosecution.
Yeah, I'm not sure if that led to seeking the death penalty or not. I know a lot of jurisdictions will have the ability to elevate an offense for certain individuals, like crimes by schools, or if you assault a police officer, it goes from simple assault to aggravated assault. But I'm not really sure if his being a Marine impacted the sentencing or the charges that fell into this case.
Well, it certainly plays into the emotional aspects of the trial, which the jury is not to consider. However, it's hard to get away from that, and we can both agree that that is certainly very touching in this case. Well, we're going to switch for a moment to the Gebhardt trial. That's the trial out of Georgia, the 34-year-old lynching by dragging case that investigators have put together within the last year based on intense, they put out feelers to see if people had any additional information, and as time goes on, cases get solved, and time seems to solve many cases. And so we're going to go into the courtroom and hear a clip of Terry Reed. Now, Terry Reed is part of this case, and we'll listen to his testimony and cross-examination. On Law&Crime Network, we're covering the Gebhardt trial. That's the cold case trial out of Georgia, where a man was stabbed and drugged at the back of a car on a rural road some 34 years ago. We just heard testimony from Terry Reed. Terry Reed was in custody with the defendant and made some confessions. Basically said that where the evidence was, and that he used to burn it and throw it in a well, and this is what prompted this jailhouse, this inmate, to contact his sisters and have them contact the GPI. We're in the studio with Brad Micklin. Tell me, sir, why do you think that this defendant, or excuse me, this witness is coming forward with this information? You know, how does the jury view these sort of jailhouse confessions?
I think it's an interesting testimony because I think a jury will often look to a jailhouse informant or testimony like you referenced, that they're getting something for testifying, a reduced sentence, favorable testimony at a parole hearing. But the witness testified when the prosecutor asked, "What are you getting for this?" He said nothing. Then the defense tried to cross-examine, and I was waiting for him to go somewhere with it because, you know, the first-year lawyers taught you never ask a question you don't know the answer to. He gets up and says, "You're not getting anything?" Witness said no. He goes, "You're not getting anything?" No. He must have asked him 4 times. And I think he hammered home the point that the witness isn't getting anything. I think it actually made the witness more credible.
I agree. And the witness even said, "I'm not asking for anything." He said that right is right and wrong is wrong, and that I'm going to serve my time. And I'm going to man up and for mine. So what do you think that this witness could have thought or was thinking when he heard this from this defendant in custody?
I'm not sure. You know, it was supposed to be that they were just, you know, communicating back and forth. There wasn't really much talk before this witness took the stand in the media and the coverage of this case about what the motive or incentive was. It was simply one of the many different people who were going to identify that the defendant did, in fact, say that he committed this crime.
Brad, I've seen this before where defendants, as time has gone by, they feel like they've gotten away with the crime, and so they then begin speaking about it, making comments, and then I've seen the other side where the guilty conscience is weighing on them, and so they want to tell people, almost subconsciously wanting to get caught or just to be able to release some of that burden and put it on someone else, because essentially by giving that information out, he's transferred the burden now to the witness on the cross, Terry Reed, who now has the responsibility to report it to the GBI, and we saw his efforts and what he did, and he got problems. He couldn't just give that information. They wouldn't even accept it. So that was very interesting in how he wanted to get it off his chest as well. So let's pick up now as we go back to more of the cross of Terry Reed and hear about what he heard in jail a few months ago. You're just hearing testimony in the State versus Gebhardt case. This is the cold case murder of Tim Coggins in Georgia in 1983. We're here in studio again with Brad Micklin. Brad, we just heard some very testy testimony. What do you think was going on there between the defense attorney and the witness?
It's always challenging to be on the stand and being sort of attacked by a defense attorney. And, you know, we heard the witness say, you're not going to put words into my mouth. So I think it was getting a little heated, and I think that the defense attorney is trying to do it. I think he's trying to sort of muster up some kind of anger, suggest that there was some other reason, like this work detail, that maybe he's here testifying for.
Well, so now we heard from Mr. Reed, and he says that after he heard the statements from the defendant admitting to the crime, and he started to tell others, inmates were talking about the crime, officers were talking about the crime, and then all of a sudden he was removed from trustee duty. Trustee duty is a very coveted position, a position of trust and privilege in the jail where you get special privileges. What do you think that was about, and where is the prosecution going with the buildup into what happened once he found out about this confession?
It's difficult to say exactly where the prosecution's going, but I think they have a lot of issues that they're trying to diffuse. And going back to the beginning of their trial, to the opening arguments, through up to this witness, you know, we had the issues that the prosecution is dealing with, like all the lost evidence, the DNA that is not only missing, but what did exist, they're claiming should have been tested and wasn't. So I think the prosecution is attempting to diffuse all these issues by bringing witnesses like this one forward.
Now, this witness, a former inmate, obviously convicted of a crime, has some criminal history. He is telling us that he's honorable, that he did his time, and he did the crime. But he's also clearing up the defense attorney. You won't put words into my mouth. How do you think the jury can weigh his testimony just sort of based off of his personality and the fact that he stands on the side if he wants only the truth to come out?
I think the jurors are going to be impacted differently. They're all obviously very different people, and that's what the purpose of the makeup is going to be. So I think how he acted, his body language, his consistency, his obvious belief in what he's saying in his conviction is going to be very important, but it's going to impact everybody differently.
And his demeanor, very calm, very matter-of-factly. He's being consistent in his testimony. How do you take that?
Well, that's always important, to be consistent. It's not surprising that he would be uncomfortable. This is a high-profile case. I'm sure he's been through a lot getting to today with investigations and reporters and being in the newspaper and having your friends and family see. So he's bringing all that into his testimony, and I think that's what the defense attorney is actually bringing out.
All right, well, we are watching gavel-to-gavel coverage in this very interesting cold case. Things are heating up. We've heard some explosive testimony. We've heard confessions from the defendant, and this is certainly a very interesting case, and we'll see how the hate allegations will certainly play out before the jury. But now we'll go to a break. More to come on the Law and Crime Network. Stay tuned. All right, you just heard the opening statements from the prosecution in the State versus Gebhardt. This is the Georgia cold case murder of Timothy Coggins, where he was stabbed and drugged behind a truck in a rural area. And it's alleged to be a hate crime because he was believed to have been socializing with a young Caucasian female. And so, you know, as a 20-year prosecutor, I just want to take a moment and say that I am very impressed with the prosecution. She is very professional, passionate, compassionate, and she immediately gives the shortcomings of the case. The due to time, much of the evidence has been gone, and so I want to give kudos to this prosecutor. Extremely impressive and powerful. Here in the studio, we have Brad Micklin, master trial attorney, and we've heard the prosecutor talk about the rage, and we've also heard her talk about the friends of the defendant. Now, this case was really made by the friends. We've heard multiple testimonies where at some point the defendant gave little tidbits. We put him there, we stabbed him, said things, they'll never find the evidence, they'll never do that again, things of that nature. Do you think that this case could be as strong if it weren't for those friends? And are they good friends?
Well, I don't imagine that they're good friends. I can't imagine it to be friends any longer. But to your question, I think that the prosecution's case needs these witnesses. I think that a lot of what we see in the opening statement is really the prosecution's attempt to pull the attention away from the bigger problems that they face, and that's going to be the loss of all the evidence. You know, there's talk that there was tire tracks that were lost. There was hair follicles that disappeared. There was a bottle of Jack Daniels that may have had DNA on it. These have all vanished. So I think what the prosecution's trying to do is take your attention away from these things and say, look, we have 3 people. They're mostly his friends, and we have this jailhouse witness who is not getting anything for his testimony, and they're all pointing the defendant as the one who committed this crime. I think that's what they're looking to accomplish with it. And
I think the weight of it, them being friends and being in position for the defendant to confess these things, and also the relationship again, and the timeliness of it all. I just think that this is very crucial testimony for the prosecution, and I think it makes the case when you add up all the little comments together and them being so familiar with the defendant that eventually they will give much consideration to the testimony that we've just heard. So we've got more testimony to hear. Now we're going to tune into Robert Smith. This is a friend of the defendant and the friend of the defendant who is yet to be tried. Let's go to the courtroom and hear what he has to say. All right, we just heard testimony from Robert Smith, yet another friend of defendant Gebhardt in the Georgia hate crime case from 1984. Joining me is trial attorney Brad Micklin. I do apologize. Okay. And so tell me this, rage. We hear that word in the opening from the prosecution, and then we hear Robert Smith say, we deal with that, meaning interracial communications. What do you think that means to you? What does that mean to you?
It's hard to say. Again, race is obviously a huge issue in this case, and these witnesses are all testifying that that was what motivated the defendant to commit this heinous crime. So I think the prosecution is bringing these witnesses to simply tie the rage issue and the race issue together and say that this is what motivated it, so we should sentence him as we are trying to.
Absolutely, and from this testimony, you can hear Mr. Smith sort of build into that rage. We're getting finally the justifications, the inner workings of the defendant's mind, how he felt about this particular situation. So it's certainly hard for him to overcome and for his defense to overcome that this was not racially motivated if he's out here telling his good friends things like this. And I thought it was pretty interesting. He says they had been drinking, and which they did a lot of. That's a common theme with the witnesses that we're hearing. And when he starts drinking, he starts talking about these concepts of, you know, what we do, we don't deal with that here, this is what happened. And then we hear about it years later when he's sober in jail, he's still talking about these concepts. So he's consistently admitting to this behavior to many different people, different classes of friends throughout a lot of time. And so the jury's seeing many different ways. What was the most, what did you think about Robert Smith's testimony? What stood out to you most from what he's told the jury?
Well, again, I think it's the fact that you have multiple witnesses that all claim to be his friends. You know, these are very credible witnesses and credible testimony. It's not like they have any kind of bias or motive. They're not receiving anything from the prosecution, at least that we know of, for their testimony. So they're really sealing his fate because they're credible and they're consistent.
Well, I love it that he was just sharing all of this with his friends, and now we're going to go in the courtroom and listen to testimony from yet another person who knew the defendant, Christopher Vaughn. So we'll listen to that testimony and we'll be back to talk about it. More on Law and Crime. We're back talking about the Georgia cold case murder trial of State versus Gebhardt hate crime. Another bomb has exploded in the courtroom. We've heard the N bomb. The prosecution has alleged that this is a racially motivated murder, and that it is because the the victim was purportedly sleeping with a Caucasian woman, and that was unacceptable at the time to this defendant, according to the testimony of the witnesses. Now, the prosecution has alleged that there was rage, and now we hear the use of derogatory racial terms. We hear the defendant saying that he believed they were sleeping together. We've got the intent. We've got the motive. Brad, tell me what this testimony means from Robert Smith.
Well, obviously the testimony is going to bring the racial issue even to the forefront once again. But more importantly, this is the second witness that has now talked about the well and the murder weapon, which I understand was recovered. I understand from the prior testimony that they recovered a knife from the well. Now, I don't know if there's any DNA evidence on it or not. So I think once we find that issue out, it's going to put the testimony of these last two eyewitnesses, or at least the last two that testified that he admitted to the crime and that he threw the knife into the well. It's going to tie it all together nicely for the jury.
Well, Brad, we're going to go to break for a moment, and we will come back and listen to more testimony, and let's see how the prosecution can put all this evidence and testimony together. This is interesting. Stay tuned. Stay with us. There's more to come on Law and Crime. You just saw a recap in the Marine murder trial outside of Kentucky, where all the testimony has concluded, and Law and Crime Network will pick up with the closing statements on Monday in the courtroom. Here in studio is trial attorney Brad Micklin. Brad, tell us, since the testimony has ended, the defense attorneys offered some motions or some requests of the judge. Can you tell us about that?
Yeah, it got very emotional at the end. The defense attorneys made both a motion for a mistrial and a directed verdict, which, as you know, either one would have stopped the trial right in its tracks. Given the amount of upset that resulted from the delay that it took for the 4 years for this case to come to trial, I think if the judge had granted those motions, there would have been outrage.
Do you know what the grounds for the mistrial was? Was it based on delay?
No, the grounds for the mistrial motion, I believe, was that they thought there was prejudicial testimony from the victim's mother, a letter that she read on the stand, which would have prejudiced the jury.
So after all the testimony had been heard, is this a common motion to ask that the case be dismissed because the burden wasn't met or some sort of impropriety in the trial? Is this something that defense attorneys often do?
I think it's common in a lot of cases. On the one hand, there's little risk to doing it. If you're unsuccessful, there's no loss to it. The only risk I think you take as a defense attorney is that the jury may wonder why you lost that motion, and that's like the last thing that they're going to take into the jury room with them.
Is that in the presence of the jury? Do they ask those motions?
Usually not. I'm not sure in this case if they did or not. So it would have to see how the actual motions were made, but I don't know what they did in this case.
Well, Brad, thanks so much for joining us today. You've given some expert testimony to us and some definitely important insight as we tackle the two cases that are going on now. And so it's been a great time here hosting at the Law and Crime Network. We'll be picking back up on these two very interesting trials on Monday. We need for you to tune back in so you can see the conclusion, and we thank you for joining us, and until we come back, stay safe. Thanks again. I'm Kenya Johnson.